Hi folks, welcome to Crisco's Corner. Unfiltered commentary. And not your truth, the real truth. Please like, share, and subscribe. And as always, thank you for your support. Hi folks, welcome back. This is an update on the Kyle Rittenhouse trial. You know, a lot of moving parts here. Let's get the long and the short of it. I've edited a little bit of what the judge had to say concerning the fact that a video came in late. I think the prosecution gave the video to the defense in a very blurred, and you could barely see anything on purpose, and kept the high definition version, which was oddly enough given anonymously, as you're going to see. And I think they did it on purpose. And you're going to see the defense didn't get that HD version of this video until after the trial concluded and the evidence could not be submitted. I think it was done on purpose. The reason why I say that is because of the fact that the prosecutor has acted in bad faith the entire time. Violated Rittenhouse's Fifth Amendment right twice. Was ripped by the judge. I mean, ripped him about doing that. And there was a motion filed for mistrial with prejudice, which means all charges are gone, and he's found not guilty without a verdict. Now the jury's deliberating. Now they're going over that, well, they found out. Well, the prosecution in their final arguments showed the high-quality HD. And the defense said, whoa, wait a minute. And of course, it was too late by then. The evidence was already submitted. And now they have three motions before the judge. Two on the Fifth Amendment issue that he violated, and he knows better. He's a experienced attorney. I think he did it on purpose to try to cause a mistrial because he sees his chances of conviction are going south. And then this video thing there, I think he also did on purpose. And you're going to see that the people that developed the software to have this fuzzy picture make it look like Kyle was pointing a gun at somebody earlier in the evening even says this is not meant for courtrooms. It should not be put in as evidence. That's how ridiculous the video could be or the picture could be when they enhance it. It doesn't really show what's really there. So let's listen a little bit.
To consider the drone footage was turned over by an anonymous person who we supposedly now know who it is, Mr. Beeman, on the first Friday of the jury. We were provided a copy of that from Mr. Krause that was neither in the length or definition clarity that the state had. We did not get the full download that they received until Saturday of Sunday of last weekend.
And that's the point. Now, the thing of it is, though, they used that video in the blurrier version and used software to enhance the picture, saying they didn't have a better copy to make it look like Kyle was pointing a gun at one of the people I believe was injured or killed earlier in the evening. And that's not true. And I think they knew that because if you focused in on the HD picture, you would have clearly saw that wasn't the case. I think they did it on purpose. And then they gave him the HD version, like you said, Saturday and Sunday after everything was done. This whole thing stinks.
After all the evidence was closed. And that's a real problem. Not to mention that since doing our research, the specific amped owner's manual says that when using AI to enhance photographs or videos, it is for investigative purposes only. It is not forensically to be used in a court of law and should be labeled as such.
Doesn't say. You're wagging your head no. Is that true?
The evidence in this trial does not say that. And I'm concerned because
I don't want to get let's not get ahead of ourselves.
See, here's the thing. The judge asked this prosecutor, this weasel, a direct question concerning the people that developed the software that he used to make it look like Rittenhouse pointed a gun at somebody earlier in the evening. That it should not be used for forensic purposes in court. The developers of the software. The judge asked him a direct question. And you notice what he did? He didn't answer it. He avoided it. Well, I think that, this guy's a slime ball. I'm telling you. I would be pissed if I was a judge. It says, Mr. Binger, I asked you a direct question. Did you know that the developers of this software did not say it was for court use in forensics, just for investigative purposes only? And of course, he didn't answer the question. I think he knew. Now, is he obligated to tell the defense that? No. But I think he knew all of this, and he tried to slip this in and got caught. We'll see what happens.
Because right now the jury wants to address this. We'll certainly have to talk about it. I have not, and I've discussed my disdain for the rule. I'm not going to box you guys into accepting what I think is the better way, and I sense from the statements that have been made that I think that in some respects you may even agree with me that it would be better if the jury could. We're going to now have the jury will come down here to the courtroom, and everybody will be shooed out of here, as they should be.
Now they're talking about the jury seeing the video in the HD clear version. Now here's what they didn't discuss, and I don't know what's going to happen. Does the defense and or the prosecution get to present it as new evidence, i.e., they get to describe what's going on and give their version of it? I don't know. Or the jury just sits there because the judge wasn't sure if he should be in the courtroom when the jury visits the new evidence, that there's going to be no explanation from the defense or the prosecution. I don't know. This whole thing stinks.
And I'm not even sure. We're going to have to review the procedure that's been outlined. But they get to watch it once? Is that what the rule is?
I think they should be allowed to view what they want to view as often as they want to view it.
Subject to my other objection, I don't have a problem with them viewing it multiple times. At a certain point, I don't think that's, 3 or 4 times, I don't have a problem to sit here and just keep playing it. I don't think that's the right way either. Then it's giving more emphasis to one piece of evidence.
Well, but sometimes there's one piece of evidence which is absolutely critical. And I talked about those Zarna. Well, can they freely talk? Which is what we want. We want freedom of expression between the jurors. And
Well, that's the thing. Are they just going to see it at full speed? Do the jurors get to see it in slow-mo? Do the jurors get to see the new HD video, the clear video, up close? I mean, focus in? Or just a big picture on a TV screen that's like 2 or 3 seconds long, probably less. This whole thing stinks. This whole thing absolutely stinks.
And so as they watch these videos, and to me, if they want to watch it 100 times, that's them. We're going to sit down with the books. We're going to find out what the exact procedure is. And we'll await what they want to do. But for now, I will answer, do we view the videos in private or in the courtroom? And the answer will be in the courtroom. You need to know the exact exhibit number.
Now they're talking about the procedure. What is the procedure? I'm not sure if it's by law or precedent. If evidence like this comes up at the last minute, what is the exact procedure? The judge is going to have the jury see it in the courtroom and chase out the public, leave the defense attorneys. I'm not sure if the defendant will be there, media. The judge isn't even sure if he should be there or the bailiff. So they're going to have to look up what the proper procedure is. That way they follow either the law or precedent.
Or video or photo. There's 2 options. One is we can just, you can have all of them. Anyone gasping? You can have all of them, whatever you want. You can pick and choose, and or you can describe generally what you want.
I think the exact exhibit number would be helpful, but if they can give us just a title or a description, we can also figure it out.
I agree.
All right, so what I'm going to write, you've got copies, so what I'm going to write on here is in courtroom, I better write, general description of what you would like. Is that all right?
Yes.
Ask about with regard to your answer, Your Honor?
Yes, sir.
I'm not sure I heard you correctly about if we bring the jury back, you mentioned something about kicking everyone else out of the courtroom. And I don't know what you're planning to do, but if you are planning on doing that, it might be helpful to tell the jury that so they understand that they will be viewing it without the public around. I don't know what you're planning on.
That's a good point. Except that I don't know exactly who are going to be the kickies. Certainly all the media and the officers, other than the media and the officers, and the question is whether the lawyers and the defendant. I don't know what the answer is. We'll have to check that. And I don't know if I'm supposed to be in here. I got the impression, and it's been a long time since I've read one of these cases, I got the impression it was actually supposed to be the bailiff.
Now, here's the thing. This is very unusual, so they're going to have to look up all the rules and procedures.
Court to consider.
Now, I'll tell you, I'll give you my personal opinion. I'm not a lawyer and never went to law school, so this whole thing stinks. I can't tell sometimes if the prosecution is just incompetent or they're dumb like a fox. It's hard to tell. It seems like he's pushing like hell to do and say things that will cause a mistrial because his preparedness for this case has been miserable at best. If the prosecutor was a defense attorney, he might be disbarred for malpractice. I don't know. I mean, it would be an appeal on the defendant. If he was my lawyer and I was convicted, I would appeal on the fact that my lawyer was incompetent. But unfortunately, he's the prosecutor. So I don't know this whole thing. Why is it so important? Not because of the rioting that might happen around the country in Kenosha. If there's a innocent, not guilty, depending on how you want to word it. I think this is important because this is going to set a precedent that if you bring a firearm, legal or not, to a situation, a tough situation like this one, and you're attacked, and you use that firearm to defend yourself, that is unlawful, or this will be a precedent. In other words, they said he brought a gun to a fist fight, and that's not quite the deal. This is a big deal on precedent on defending yourself. Now, I'm not up on Michigan law, but precedents lawyers and judges love. When I used to be a city councilman, I know that the city attorney, when we talk about certain things, well, is there a precedent? Is there a precedent? They love that stuff. That way it stops, they don't have to make a tough decision. They can use a ruling from another trial or another judge. This will set back self-defense with firearms back dramatically and take a huge hit on the Second Amendment. And these idiots know this, and I use the word idiots on purpose. I have absolutely no respect for the prosecutor and his assistant. By the way, the prosecutor is not the DA. He's the assistant DA because I think the DA was too smart to get involved in this. But anyway, that's the update. So they're going to let the jury look at the video, how and when, and in the courtroom here, and how they're going to be able to let them look at it. I really don't know. Will the lawyers be able to interject and talk about it? I don't know either. We're going to have to see, but that is the current update. And that's the way things are. And so until we find out anything more, until next time, goodbye and good luck.